So I want to welcome everybody to the Minerva seminar, and we have the pleasure tonight of listening to Dr. Rottem Rosenberg-Rubins, who is a postdoc in the Minerva Center, and she's going to talk about from a state of exception to hyper-legality, Israeli counterterrorism law in the post-two-state era. And after Rottem gives a presentation, we're looking forward to a discussion. So Rottem, please.
Hi. So thank you all for joining us at this late hour. My talk today focuses on the comprehensive 2016 Counter-terrorism Bill, which was introduced by the Israeli government. The bill introduces aggravated sentences for existing security offenses, as well as several new offenses, many of which are preventive by nature, meaning offenses that criminalize behavior that may prove to enable future terrorism. The bill permits extended periods of interrogation and pre-charge detention for terrorist suspects compared with those allowed for suspects of non-security offenses. And it entails powers to seize assets belonging to groups linked to terrorist activity, as well as other administrative powers. The bill also replaces several of the 1945 Defense Emergency Regulations, as well as other emergency legislation, and replaces it with permanent statutes. My research attempts to identify the underlying logic of this counterterrorism legislation, and more specifically, the type of relationship that it envisions between Israel and the occupied territories. As we will see, while the bill is formally domestic and applies in the state of Israel, it was largely designed with the Palestinian residents of the occupied territories in mind, particularly those of the Gaza Strip, but not only. Before I begin with the bill, a word concerning the boundaries of the research. My current research doesn't provide any empirical data yet about the manners in which the legislation is being implemented on the ground. I haven't looked into the concrete decisions yet that are reached in accordance with this law. This will be my next project. The current project focuses on a critical analysis of the legislation itself and the legislation process, and I do so by providing a close reading of the final legislation, the memorandum bills, and the protocols of the Constitution, Law and Justice Committee that drafted the bill. So the objective of the bill, and I'll just summarize quickly in English, Clause 1 states generally that the purpose of this new law is to create criminal and administrative tools for combating terrorism, while taking into account Israel's commitment to international treaties and to human rights. And the memorandum bill, which you see a part of here on the screen, it elaborates upon this objective, emphasizing the need to strike a better balance between combating terrorism, the need to combat terrorism, and the need to uphold human rights and civil rights. And here you see from the memorandum bill a quote from a former Supreme Court Chief Justice Aaron Barak, who has famously stated that we must find a balance between security and human rights, as only a strong and safe democracy can ensure human rights, while only a democracy founded on human rights can be secure. So this is very sort of a legalistic constitutional rhetoric, which draws on the field of constitutional law and relies on an opinion that is considered both canonic and quite liberal, Aaron Barak's opinion. And while it might be tempting to sort of dismiss such rhetoric as mere lip service, it should be noted that in many respects, legislation and the legislation process did comply with constitutional standards and with the basic principles of the rule of law. First, one of the objectives of the bill was to consolidate previous counterterrorism legislation that existed in Israel, while canceling some previous laws and regulations which were considered to put too little emphasis on human rights or considered outdated. This was done only partially, but as we will see, some of the 1945 Defense Emergency Regulations were annulled in this process and replaced with this primary and permanent legislation. Additionally, some procedural rights were added to the bill, as we will see, the right to a hearing, the rights to a review process, The legislation also included an amendment to the Public Defender's Office to ensure that those who were tried with offenses in accordance with the law would qualify for legal representation. The second point is one that Professor Eli Salzberger actually made last week at the end of Dr. Yoav Mechuzai's lecture. I think he mentioned that the legislation process was actually a very elaborate one, and one which included opportunities for various organizations to voice their objections and concerns and influence the legislation. I remember in 2009, when I was still an intern for the National Public Defender's Office, we received an initial draft of this legislation, and I was assigned to the team that wrote objections to the law. Many of these objections were, of course, rejected, but some of them were incorporated into the law, and a similar process took place with human rights organizations and various other organizations and state organs who were given the opportunity to voice their objections and concerns. And third, and very interestingly, the bill formally applies to all terrorist suspects and organizations whose actions jeopardize the state of Israel, whether they are Israeli citizens or Palestinian residents of Gaza, and to some extent also the West Bank. In this sense, the bill must be read together with another piece of legislation, which is the 2006 amendment to the Israeli Criminal Procedure Law. And this amendment to the Israeli Procedure Law was submitted to Parliament shortly after the Israeli disengagement from the Gaza Strip, and its aim was to substitute the law enforcement powers previously executed by the military commander of the Gaza area. Accordingly, the statute was originally intended to apply only to suspects who are not Israeli residents. But during the legislation process, it was decided that this would be problematic from many respects, from an equality standpoint, and it was decided that the legislation would also apply to residents and citizens of Israel. So this amendment, this 2006 amendment, contains special instructions regarding the interrogation and pre-charge detention of detainees suspected of security offenses. It enabled the interrogation and detention of such suspects for longer periods, sometimes in extreme cases, even in the suspect's absence. This amendment was consolidated into the 2016 Counter-terrorism Bill, which in its entirety will likewise apply to the Palestinian population in Gaza, which is now brought to trial in Israel after the military courts in Gaza were abolished. Also, the bill entails certain arrangements pertaining specifically to suspects and witnesses who live in both Gaza and the West Bank, indicated that some of its powers are expected to apply to both populations. And when it comes to the application of the bill, so we see, first of all, these special rules concerning the testimony of non-residents, including Palestinian residents of Gaza and the West Bank, all kinds of special arrangements designed to make it easier for such people to testify without appearing in court or to give testimony in other ways. Another thing interesting about the law is that while it applies, of course, to internal offenses, meaning criminal offenses, security offenses that take place in Israel or partially in Israel, it also expands the category of external offenses that are not committed in Israel that can be tried in Israel. So it defines a group of security offenses as offenses that will automatically be considered external offenses that are permissible to try in Israel. I want to go over some of the special powers stipulated in the law, and I want to do this quite briefly because I don't want to bore you with too many details. The legislation is quite long and elaborate, so let's just look at the main powers. And you can basically divide these powers into two: administrative powers and judicial powers. When it comes to administrative power, one interesting development that took place in the legislation was that according to the legislation, the Minister of Defense may declare an organization or an individual as a terrorist organization or a member of a terrorist organization, respectively. And this decision is made in accordance with certain criteria that I will not go into. What I do want to give more attention to is that we see here arrangements that actually replace parallel arrangements that existed in the 1945 Emergency Defense Regulations, and the bill amended the previous mechanism for declaring terrorist organizations and members by adding a right to a hearing that did not previously exist, and by forming a special advisory committee to the Minister of Defense. Now, this committee is comprised of a former judge from either the Supreme Court or the District Court, a lawyer who is eligible to become a judge, and someone from a counterterrorism background. The job of the committee is to advise the minister on these decisions on declarations, including decisions on hearings and requests for a cancellation of the declaration. The committee is also required to revisit decisions to declare an organization or an individual terrorist every 4 years, meaning that we have this periodical review process that did not previously exist. Other administrative powers include powers of seizure and confiscation of property linked to terrorism, prevention or limitation of use of territory, which is the power of the police, not the Ministry of the Defense, and decisions to delay bringing suspects before a judge, also a police power. So when it comes to seizure and confiscation, here we see that the parallel emergency regulations were canceled only partially. Some of the regulations would grant similar seizure powers to the military or the police still exist alongside the Counter-terrorism Bill, while other regulations were canceled. Similarly, when it comes to the prevention or limitation of use of territory, the Counterterrorism Bill allows the police to prevent an individual from entering or using a place or a territory that the police suspect is being used or will be used for terrorist activity. And this may apply, among other things, to such activities as rallies and demonstrations. And here too, some parallel emergency regulations were canceled, while others continue to exist. The main change introduced in the Counterterrorism Bill is that here too, a right to a hearing was added. And finally, decisions to delay bringing suspects before a judge. This is actually part of the aforementioned 2006 amendment to the Israeli criminal procedure law. It states that a police officer may deviate from the regular rules of criminal procedure and delay the court appearance of a suspect arrested for a security offense. This is now part of the counterterrorism law. As for judicial powers, I'll go over it very quickly. The first two categories are also part of the aforementioned 2006 amendment to the Israeli criminal procedure law, extended pre-charge detention in the cases of security offenses, pre-charge detention orders in the absence of the suspect in extreme conditions. These are two clauses that are added to the law. Just to be absolutely clear, we're talking here about regular pre-trial detention, criminal detention, not administrative detention, but regular criminal detention that deviates a bit from the regular criminal procedure rules. Finally, we also see new aggravated and preventive offenses added to the law, and also powers to seize assets following a conviction. I won't say too much about these categories because it would take too much time. Okay, so I want now to try to sort of take a step back from all these clauses in the law, and to try to talk about some preliminary conclusions that will serve as a starting point for our theoretical discussion. First, the formal narrative behind the law, which was pushed mainly by state representatives who drafted the legislation, was that this law was required due to the new and unique challenges associated with terrorism, especially after the disengagement from the Gaza Strip, and also due to the need to consolidate and update prior legislation that was outdated and inconsistent with democratic values. According to this narrative, the Counter-terrorism Bill is an improvement from the viewpoint of human rights and the rule of law. It was presented by the Department of Justice as an attempt to strike a new balance between law and emergency, between emergency measures and more conventional legal measures from the field of criminal law and criminal procedure. And to a certain extent, this is true. However, I would like to suggest that what we're seeing here isn't simply a new balance between law and emergency, but a formalization or an institutionalization of the strategic combination of law and emergency. This is evident in the fact that the bill does not cancel or most emergency legislation, such as the 1945 Emergency Defense Regulation. Instead, the bill was drafted with one eye constantly on these regulations, with parliament members and representatives of the Department of Justice emphasizing that the idea is to allow the state to use both sets of tools interchangeably, albeit by giving some dominance to conventional measures over emergency measures. And this reality corresponds with arguments made by such scholars as Dr. Yoav Mechuzai, who spoke here last week, and who argued that law and emergency are not distinct and binary categories, but categories that typically work together to create a joint regime. And in this regime, emergency powers become just one more tool in the arsenal of legal tools. Finally, we see that the Counter-terrorism Bill was enacted with Palestinian terrorists and terrorist organizations strongly in mind. This is clear from the protocols of the Constitution, Law, and Justice Committee, in which most of the examples cited by members and participants relate to organizations operating in Gaza or in the West Bank. It is clear from the discussion that the main purpose of the legislation is to prevent these groups, Palestinian groups, from functioning and their plans from materializing. Yet, the law is, of course, Israeli legislation, which applies in Israel. And as I have mentioned, I think it does not abolish the legal segregation between Israel and the Palestinian residents of the West Bank, at least, who are typically still tried for security offenses in the military courts. Okay. So based on these preliminary conclusions, my research focuses on three main questions. The first question pertains to the underlying logic of the new legal regime and the new balance struck between law and emergency. And here what I want to do is I want to attempt to move beyond the law-emergency dichotomy or spectrum. I argue that it's not enough to characterize this regime as a law-emergency hybrid, but that this institutional combination of law and emergency has its own distinct logic, which I will attempt to characterize. The second research question pertains to the way the new legal regime understands terrorism, and particularly Palestinian terrorism. How does the legislation view terrorism? Is it conceived as a military conflict between a state and an entity external to it? Or is it conceived as a threat that materializes within the state? Is the terrorist confined to the traditional category of the enemy? Or can a terrorist also be a formal friend who is a member of the political community and even a member of the Jewish majority? And finally, taking into account the answers to the first two questions, how does the legislation view the Palestinian residents of Gaza and the West Bank and their relationship with Israel? Does the legislation signify a retreat from the two-state solution? And if so, which status does it designate to Palestinians in the one state to be, in the civic hierarchy of the one state to be? I'll begin with the first question. And here, what I suggest is that the new counterterrorism legal regime is consistent with what Nasser Husain has termed hyper-legality. Hyper-legality is an inflation of laws, rules, and legal mechanisms that causes the subject of power to be over-regulated rather than abandoned by the rule of law. Husain argues against the tendency to view emergencies as a temporary suspension of rights in response to a specific crisis, such as an invasion or attack. He points out that today, most emergency laws are neither temporary nor categorically distinct from a larger set of state practices. They are among many other legal tools that the state may utilize at its discretion. Moreover, they do not constitute a reactive and event-driven response, but a structural and permanent one, which focuses on prevention of future terrorism rather than on ad hoc retaliation. And I think we certainly see signs of this tendency in the Counterterrorism Bill, which is a comprehensive, permanent, and primary legislation that complements prior forms of emergency measures rather than replacing them completely. In such counterterrorism regimes, the law does not withdraw in face of an emergency, but lives alongside it. The rule of law is not suspended, as is described by scholars such as Giorgio Agamben and others, but quite the contrary. Legality is in a manner intensified. And the question is, what differentiates hyper-legality from regular legality? And here Husain tells us that there are two distinctive features, two main distinctive features. First, the increasing use of classifications of persons in the law, and the second is the use of special tribunals and commissions, and the establishment of special procedures and such tribunals. So when it comes to classifications, hyperlegality creates new subcategories that represent different levels of threat in the eyes of the state. For example, we may be accustomed to using such terms as enemy and friend, or citizen or non-citizen. But today we also have many intermediate legal categories, such as enemy combatants, enemy nationals, terrorist suspects, infiltrators, unauthorized migrants, and so on and so on. This process of classification has a strong predictive quality, combining who people supposedly are with what they are supposedly likely to do. And consequently, it involves many racial and cultural presumptions. So it's a bit like racial profiling in a sense, but unlike racial profiling, Husain tells us, and I agree, hyperlegality does not exactly classify its subjects by race or any predetermined personal characteristic. What it does is classify individuals into legal categories and then use these classifications to enable the use of new and specific legal powers. So for example, if the legal category member of a terrorist organization that exists in the Counterterrorism Bill allows the state to use special detention or surveillance powers or other special powers, then it is only expected for people whom the state thinks that should be subjected to these special powers to be defined as terrorists. And it's not necessarily done in any sinister way. It simply happens because these definitions are quite flexible. They allow a lot of state discretion. And it's also very important to note that, at least formally, these categories have nothing to do with race or nationality. Now, of course, if Palestinians are most likely to be perceived as those who it is important to subject to these special measures, then it's much more likely that Palestinians will be defined or be declared as terrorist members of terrorist organizations, or the Palestinian organizations would be defined as terrorist organizations, up to the point maybe that terrorist and Palestinian can become almost synonymous, but formally speaking, terrorist can also be Israeli. It is not necessarily Palestinian. And so we see this tendency in the Counterterrorism Bill to formalize and all kinds of these legal categories, such as member of terrorist organization, and suspect of security offense. And once an individual is placed within this category, the state gains access to specific legal tools and remedies that otherwise would have been more difficult to exercise. So this is the first main distinguishing feature of hyperlegality. And the second distinguishing feature is the use of special tribunals and commissions, the creation of special venues in the law, as Husain calls it. In this sense, anti-terrorism laws represent the fragmentation of the criminal justice process in which different offenders and different offenses are subjected to special legal regimes. We see that's not only in counterterrorism. Think, for instance, of special laws like those that exist in Israel pertaining to sex offenders that allow special supervision of sex offenders that are released from prison, okay? Or think about the special drug courts and community courts that exist for certain type of offenders, or special courts for juvenile offenders this is, of course, not the same as these mechanisms for combating counterterrorism, but it's part of the same fragmentation of the criminal process that exists in hyper-legal regimes. And again, we see examples of this in the Counterterrorism Bill. Perhaps the strongest example is this establishment of the new committee, right, the advisory committee to the Minister of Justice that has to apply these very sort of legalistic terms and can conduct hearings and review processes. This special mechanism that was added to the Counterterrorism Bill is sort of very typical of what Husain terms hyper-legality. So this, I think, is the answer that I would suggest with regard to the first question, the overall logic of the Counterterrorism Bill. As for the second question, which pertains to the underlying understanding of terrorism, here I argue that the Counterterrorism Bill signifies a gradual shift from an armed conflict paradigm for combating terrorism to a homeland security paradigm. While the armed conflict paradigm perceives terrorism as a military conflict between a state and an entity that's external to it, the homeland security paradigm views terrorism as a threat that materializes at home and that must be combated mainly through local, domestic, civilian law enforcement apparatuses. So shifting the focus, at least partially, to the domestic field of criminal law, which is primarily designed for citizens of the state, is definitely a manner of exercising this view, and this is what we're seeing, partially at least, what we're seeing with the counterterrorism law in Israel, and we're also seeing this becoming more common in other countries, such as the United States and the US. Now, another way perhaps of defining this would be to say, or perhaps a criticism of what I just said could be to say, look, I mean, it's true that we're using the domestic mechanisms of criminal law, but this doesn't mean that terrorists aren't perceived completely as enemies. It just means that they are enemies that are treated a bit differently. And here it is definitely possible to suggest that the counterterrorism legislation is an instance of what Gunther Jacobs has termed enemy criminal law. Jacobs advocated enemy criminal law as sort of a separate criminal justice procedure for non-citizens who are a threat to the state's security, who do not respect the basic values of the state. And enemy criminal law is one that is a type of criminal law that is characterized by many preventive offenses. It uses disproportional sanctions. It tries to attempts to punish preemptively, and we definitely see signs of this maybe in the counterterrorism legislation. But I also think that if we do use this sort of distinction that Jacobs proposes between enemy criminal law and citizen criminal law, which is the regular criminal law of citizens of the state, then we also have to agree that the counterterrorism legislation strikes a new balance between the two. It is not completely an instance maybe of citizen criminal law, but again, we are left with the same conclusion that it creates a new balance between enemy criminal law and citizen criminal law. And if this is true, then I think it's very interesting to think about what that means for Palestinian terrorists who are now treated with a combination of these two types of law. And I would like to suggest that perhaps this is a sign that Palestinians are gaining sort of an intermediate status in Israel, one that is certainly not akin to citizens or residents of the state, but that is not complete outsiders or enemies either. And this brings me, oh, sorry. Sorry. Okay, so this brings me to my third research question, which pertains to the manner in which Israel perceives its relationship with the Palestinian, with the occupied territories, with the Palestinian residents of the occupied territories in sort of this post-two-state solution. I'm coming to an end. This is the last part of my lecture, and one in which I want to try to be particularly cautious, because obviously this counterterrorism legislation is quite a narrow prism through which to try and examine such a big issue, such as where the Israeli-Palestinian conflict is going, or whether we have truly entered this sort of a new phase, this post-Oslo or post-two-state solution stage. So I'm not going to try to make any predictions about the future, but I do want to try to make an observation. And with that, I will end. We saw that to some extent, the Counterterrorism Bill perceives the occupied territories as a de facto part of Israel, in the sense that it views Palestinian residents accused of security offenses as a type of homegrown terrorists. Now, of course, this does not mean that they are treated equally to Israeli citizens. However, the shift to the homeland security paradigm does come at the price, so to speak, of adopting at least some of the rights and protections inherent to the conventional criminal process. So my hypothesis is, or sort of a thought, is that maybe the new balance struck between principles of enemy criminal law and citizen criminal law does indicate that Palestinians are gradually acquiring an intermediate status in Israel of sort of inner enemies or diminished citizens. And here I think we should also remember that the law applies also to Israeli citizens, some of whom may likewise be classified as a particular security threat under a one-state solution. Now, this is true for Palestinian citizens of Israel, but it could also be true, for instance, for Jewish settlers of the West Bank who commit hate crimes and terrorist acts against Palestinians. We're now seeing the beginning of this attempt of the Israeli prosecution to also try Jews who committed acts against Palestinians in accordance with this law. It's the very beginning, I think, of this process, but it is starting. And such groups may also find their membership status securitized or deflated in this hyper-legal regime. In this sense, the counterterrorism regime might potentially contribute to civic stratification in Israel, meaning a creation of a civic hierarchy in which Palestinian residents of the occupied territories receive the lowest status, but are part of the general hierarchy nonetheless. At the very least, we should consider the significance of Israel's new understanding of Palestinian terrorism as a permanent occurrence, which must be dealt with via permanent measures. I believe that the formalization of the unified law emergency regime, the idea that this regime can be a permanent or long-term solution, may also signify an understanding that Palestinians have acquired a permanent position in Israeli society. And what position precisely this will be is a matter for future discussion, but I think it's important to consider the possibility that in the eyes of the Israeli government, a type of diminished membership status, which entails reduced rights compared with those granted to citizens, but does incorporate certain rights and protections, may constitute a potential model for governing Palestinians in the two post-state era. And I think particularly telling in this respect is the addition of all kinds of procedural rights to the counterterrorism regime, to the Counterterrorism Bill, because procedural rights seem to me exactly the type of rights that this type of third-class citizens or diminished citizens would receive in such a regime. Rights that are not unimportant, they definitely might lead to more just outcomes in individual cases, but they hold no necessary guarantee for substantial justice or for substantial equality. Thank you.
Rottem, it was fascinating.
Thank you.
Really enjoy it. We have 3 people who are already going to comment, and then we're going to open it up for more. There's Gadi, Eli, and Shlomo. I thought maybe we'll let Shlomo do it first, Gadi, just because Shlomo has written an article on the governmentalities of infrastructure and services amid urban conflict, East Jerusalem, in the post-Oslo era. So he's kind of looking at this from a parallel aspect, and I think it'll be interesting to hear him and then perhaps comment on on both. So, Oren, you have to unmute. Hi. Okay.
Okay. Thank you, Rottem, for a fascinating paper. And I think what I have to say about in relation to your lecture, it's not in regard to the legal specifics, but more to the last part of your paper, which asks what is the meaning of what's the implication of this development on a broader look on the relationship between Israel and the Palestinians or the occupation state. And I do agree that this is one manifestation of what we can call the dynamics of occupation, in the sense that we cannot look at it as a temporary occupation. And if it's not temporary, so it develops. And it's been 50 years already, and I think we start to see now in the what we can call the post-Oslo area, all kind of new developments which might be called as encroachment of all kind of legal practices, land grab practices, informal land grab practices like Sandy Kedar talks about, services, infrastructure services practices which mediate some kind of government in the occupied territories. And I think one of our suggestions is just that we talked earlier this semester, just to try to integrate few point of view from different disciplines and from different aspects, and maybe try to generalize about what is this thing that develops and how we can characterize it. And I think this work is really doing a good job in that, in just putting one layer of explanation, of a possible explanation of the dynamics of occupation. Maybe we can see through that some kind of a new regime and new governments, or how the one state or a future annexation will look like. So this is a great contribution, I think, to a really needed new discourse about the occupation.
Thanks. Yeah, I want to just say that the talks that we had earlier this year really helped me, I think about this project in a larger perspective. And I think that, well, I agree with you that there's much needed. There's a lot of need for more research about this sort of new dynamics that are happening in the post-Oslo area. And what I did want to say, and thanks for reminding me, because you said that it's very important to look at things that are happening on the ground and from different perspectives and disciplines. And I completely agree. I think it's especially important since, at least until recently with the Trump plan, and even now, I think, one of our problems is that our government, our political leadership, if we can call it that, isn't really telling us what it wants as a sort of on the macro level, on a long-term solution. It's not really clear, at least to me, right, where this is going in the eyes of the Israeli government. And I think that one of the ways to try and sort of deal with this is to try and look at the micro level. And I think that that's what you're trying to do with your work, and I'm beginning to try to do with my work here in this project. So thank you.
I'm not sure that we've totally buried the two-state idea, but Gadi, let's hear.
I hope you're right, but I don't. Yeah. I mean, okay. Yeah.
Just want to close with one sentence, with your permission, in regard to your last answer, Rottem. I think that's things that we inspect on the ground might be inspected also on the level of the mediators that works things on the ground. It means like people that works in the legal administration of the occupation, all kind of professionals in different aspects of managing their life over there. So that there are like bureaucracy level which mediate these developments, which I think should be one of the main objects of investigation. Yeah.
Thanks. Gadi.
So thanks very much, Rottem. It's very mind-boggling and mind-provoking. It's a very good lecture. And actually, I liked very much the structure. So you began with the more micro level and did some theoretical extrapolation, and I liked it a lot. So I would like to begin with two more generic questions or comments. Firstly, the title of your talk has been suspension and hyper legalization or hyper legality. And I was wondering whether it might not be the same, namely that in order to stimulate or encourage a suspension, you are using hyper-legality. Part of that question, I was not really sure how do you define hyper-legality. Is it a matter of quantity? How many regulations have been enacted or stipulated? Is it a matter of quality, prohibitions on human rights and abuse of human rights? So I was wondering how really the whole definition of hyperlegality, which is a very interesting term, I'm not sure how does it help you to better understand the topic of your research. So I was very interested in you explaining much more. My second generic question or comment, I was wondering which way has not been taken. Namely, we have a order of prevention of terrorism from 1948. So is the current law better or worse from a perspective of democracy? Have we taken a better road of democratization following 1948, or is it even worse, and in what way? So maybe I would like to hear more about that kind of a comparison, obviously in a nutshell, because you don't have enough time to compare between the 1948 order and the current legislation. Then I have a third, actually generic common question, which is follow-up on Oren comments about the whole political rhetoric and political motives behind the law. Is it not really an attempt to do or to incite criminalization of Palestinians, mainly in the West Bank, because this is a main political issue right now regarding the direct control of Israel with military force over the West Bank? So is it not a replacement of a political attempt to resolve the conflict through a criminalization? You do deal with that, but I think my impression was that you are not really pushing it forward as you could have. Now, two last comments, which are really very concrete questions. You mentioned the whole issue of detentions, which is a major issue of criminal detention. And you talked about pre-charge detention, and if you can elaborate more on the conditions of pre-charge detention. And my second more concrete question is about judicial review. This would be a major issue, and you didn't talk about it as much. If you can just add some elaboration of judicial review regarding counter-terrorist efforts. But thanks very much. It's a wonderful talk.
Thank you. Well, so those are a lot of very, very important questions. I'll try to answer my best. So Maybe I'll start with the smaller questions. When it comes to judicial review, it really depends on which mechanism we're talking about. Some decisions, administrative decisions, you can, after you have a sort of review process or appeal process by this advisory committee, then, or by the police, then you can go and to court. I mean, you can always file a petition either to the administrative court or in some cases the High Court of Justice. When it comes to criminal detention, then the review process is very sort of structured. It's the same review process pretty much that exists with regard to regular detainees, which means that you have an automatic right to appeal your arrest in most cases, and then in some cases you also have the right for another appeal if the court, if the Supreme Court allows it. And this is also, I think, some of the answer to your question on criminal detention. Really, what we saw in the 2000 amendment to the arrest law, the criminal procedure law that was added to the Counterterrorism Bill later, what we really saw is actually an attempt, in the case of, especially for Palestinians from the Gaza Strip, to use regular criminal detention that exists in cases of suspects in Israel. Israel is one of the countries with the highest rate, by the way, of pre-charge and pre-trial detention. A huge percentage of, I don't remember the exact numbers, but a very big percentage of people in jail in Israel are actually not convicted of crimes, but are detainees. So in this sense, I have to say that I think if you ask first about improvement I think that if this law would cause, for instance, and I don't know if this is what happened, but if, for instance, this law could help create conditions for detaining most terrorist suspects through the conventional criminal process and not through administrative detention, for instance, and this would be an improvement, because in this sense, I think the law is pretty constitutional. I mean, it says that you can put someone in pre-charge detention for a little longer than a regular suspect. That's not ideal, but we're not talking about years. We're talking about days, okay, a few days. It says that you can extend the detention order with the suspect not actually in court, but it's only in pretty extreme conditions. This is after actually the Supreme Court intervened and annulled one of the clauses in that 2006 law. So, I mean, generally speaking, I would say that this is not such a bad example, if you ask me, for my personal normative opinion, of a way to sort of take the regular, conventional criminal tools and just amend them a little so that they would be also applicable for terrorist offenses. And, I personally have a big problem as I'm also, in my profession, a defense attorney. I was a public defender for a while. And personally, I have a lot of problems with the fact that so many people are arrested and detained in Israel when they still have the presumption of innocence. But in this sense, I don't think that there's a huge difference when it comes to terrorist suspects. Now, as for the improvement that the law introduces, I think generally speaking, my research is not normative. It's more descriptive and explanatory. And I think that it depends a lot. I think there are many ways to look at this. And in certain ways, there are improvements here, right? I don't think procedural rights, for instance. The main improvement or the main addition in this law really has to do with procedural rights. Hearings, review processes, all kinds of, more sort of a clear criteria sometimes for making decisions. This, as I said, does not necessarily promise substantial justice or equality, but there is, I think, an improvement. It does constitute a certain improvement from the terror laws that were canceled, because this type of procedural of procedures that officials have to make, they have their own they have their own logic. When you have to sort of be open and more forthcoming about your decisions, and you have to think about it, and you have to work with criteria, it does sometimes bring justice in individual cases. What I'm more worried about is that these improvements, these procedural improvements, these individual improvements that I think will happen, to a certain extent, will sort of cloud us from looking at the bigger picture here, which is that these are, in a way, also second-rate rights, because, as I said, you can conduct the procedure as openly as you want and as many times as you want with the many appeals and still reach the same decision, the same substantial decision. And in this sense, I definitely think that there's something to be said for what you said about the criminalization of Palestinians. I don't think that the law is all about replacing the political solution with the sort of legal or criminal solution, because some of the things in the law are certainly offenses that are maybe a little aggravated now, maybe some of them are problematic from the standpoint of substantial criminal law, but there are offenses that the court is the one that will have to decide whether the offense was committed. There will be a review process, there will be an appeal process, and everything. But I definitely think you have a point when it comes to the more to the administrative powers, because the administrative powers in the law, this is, I think, maybe the part where it might even get worse, right? Because now we're sort of normalizing and institutionalizing this, and definitely, I mean, the law would enable the police to shut down protests, to shut down organizations that maybe are somehow linked with Hamas, for instance, but also are charity organizations or political organizations. I think it will be definitely hard to draw a line sometimes between these distinctions, and definitely it will enable Israel to, sort of criminalize a lot of political activity. But we also have to remember that similar powers also existed in the defense regulations. So in a way, in this sense, it isn't necessarily worse. I answered in a very lengthy way, and I want to also answer your first question about hyper-legality. Okay, the truth is this. Husain's article on hyper-legality is, I think, fascinating, but it's not very long and elaborate, and it deals specifically with Britain. I mean, so not only with Britain, but it focuses on counter-terrorism legislation in Britain. So in the article itself, not all the questions that you asked are answered. And I think there are important questions. For instance, is it more a question of quality or quantity? When it comes to the first point you made about my title, I think I'm probably going to change the title. It's a working title. I don't think it's very good, but at the moment. But I think that Husain, the first question, when you said, can hyper-legality be used to suspend rights? I think Husain would probably say no. I'm not sure I completely agree, but I think that he suggested what we're seeing here is not a suspension of rights, but actually a sort of very elaborate legal process which can cause many of the rights, to be not suspended, but maybe I don't know, reduced. But I don't think that he would view this as a suspension. If it's a question more of quality or quantity, I think that's not exactly clear from his article, at least to me. For me, I think the reason that hyper-legality really helps, or helps more than the categories of law and emergency, is that it allows us, first of all, to understand the categorization that happens in the law, and to sort of better understand, I think, how these categories can be sort of, in one sense, national or racial, but in another sense, very sort of objectified and legalized, which I think is something also of a warning sign. And I think also that these special venues, and this also has to do much with classification, because what we're seeing is sort of how the criminal process is fragmentized into all these different groups, and each of them has its own sort of special venue. I think that this is something that I personally see in criminal law. For instance, in Israel, it helps me understand a lot of tendencies and a lot of things that we see on the ground that I'm not sure that the categories of law and emergency really help us understand as much. But I definitely think that I need to think a little more about this, and exactly why I think hyper-legality does the trick better than the other. Thank you. I'm sorry that it was such a lengthy answer.
Toda rabba. Eli.
Thanks, Rottem.
Eli.
Good evening, everyone. Rottem, congratulations on this excellent presentation. But I must say that I beg to differ. your analysis is based, your entire analysis is based on the conjunction that this law is designed, designated to Palestinian, and mostly to Palestinians who are not Israeli citizens. This is not true. If you look at the law that this law replaces, the Counterterrorism Ordinance, it was used almost exclusively against Jewish terror organization. Etzel and Lehi in the 40s, and then the Jewish undergrounds in the 80s. Only in the mid-80s, they started to utilize this ordinance against Palestinians. So I don't think that the characterization of the law as criminal enemy law, and by the way, this criminal enemy law concept, which was offered by a German philosopher, was adopted in some countries. I think Spain, for example. This law applies to everyone, not only to non-citizens, actually especially to Israeli citizens. So this, I think, makes a very, very different picture with regard to the law in the context of the two-state solution and the Israeli-Palestinian conflict and so forth, so on. I think this is one point. A second point relates to the shift from emergency to normality. It's true that the previous law was contingent on emergency regulation, emergency declaration. This law is permanent. And the question whether this is a shift from emergency rule to normality, which is an emergency rule. And I think the debate is open here, because terrorism now is part of normality. And the law doesn't have, it's very important to look at the details of the law. The law doesn't have, most of the powers in the law are not draconic, are subject to judicial review. The law itself, by the way, because it was enacted after the revolution, the constitutional revolution, is subject to a constitutional review. There are many, many checks and balances mechanism. You described some of them, for example, the declaration of a terror organization, the fact that there is a committee, so you explain it as categorization and hyper-legalization, but the fact that there is a committee comprising of 2 judges, and this decision of declaration of a terror organization can be brought to judicial review, and there is a early warning, and there is really a process that I would subscribe to in a democratic country for normality and not emergency. And this relates to the third point. One has to analyze the law in comparative perspective. And from comparative perspective, with regard to a comparison with enlightened democracies, this law is quite balanced. I think that there are some issues that we can debate about, as the law exceeds too much or violates human rights too much. But all in all, in comparative perspective, this law is better than the British laws on anti-terrorism, the French laws on anti-terrorism, and it's comparable with the German law, and it's much, much better than the Patriot law. And this is maybe the last point, the procedural factor. The law was enacted over almost a period of a decade. You yourself mentioned that you were commenting on some earlier drafts of the law. In a period in which Israel didn't experience a lot of terror attacks. So I think the outcome would have been much more extreme if this would have been a period of terrorism. And if you compare it to the American Patriot Act that was enacted a few weeks after the 9/11 attack and was prolonged, and now it's a permanent act, I don't think that there is a room for comparison, or the comparison is in favor of our legislation. So the main point, I'm going to back to the main point, if you look at this law as designated only to Palestinians, maybe the conclusions that you make are true, but I think this conjecture is totally untrue. And the whole issue, the lot of debates, by the way, about the law was about new kind of terrorism, Jewish terrorism, and terrorism which is not on the background of the Israeli-Palestinian conflict. And I think that this is, you know, a generic law that has some flaws, but all in all, I wouldn't raise this flag as the most important flag to combat these days.
I have to say, apart from your first point, which is important, and I'll come back to, all the other points you made are points that I made myself in my lecture and completely conceded. And I think that what you're saying is exactly what I said, that we are seeing a certain shift from emergency to normalcy here for all the reasons that you mentioned. I also agree that comparatively, and I also mentioned this myself, this law is quite similar in many ways to other legislation. For instance, counterterrorism legislation in Britain, and I'm sure I'm not an expert like you on this legislation, at least not yet. There will be a comparative component to the research, but I agree that it's sort of more akin to other laws that exist in other countries, and I think that that's exactly the reason that it's so important to look at this sort of normalization or this new balance struck with regards to the Palestinian population. And here I think is the only place where we really disagree. Of course, as I also said in my talk, formally you are correct. Formally, this is an Israeli law. It's for Israeli citizens, and it will apply to Israeli citizens. Of course, also to citizens, to residents of Gaza who are now tried in Israel. But the truth is, when you look at the legislation process, I mean, when you look at the protocols of the committees, it's true that Jewish terrorist organizations are also brought up. Those do not seem to be the terrorist organizations that the legislation is most concerned with. By the way, the legislation initially was supposed to also include a normalization of administrative detention within Israel. So here, I think you were absolutely right. It was supposed to be something that was specifically for Israeli citizens, making it easier, especially for Israeli citizens to be detained. But this part was taken out of the law. It was separated into a different legislation, which has still not been promoted. When I look at the committee, and when I look at the time in which this legislation process begins after the disengagement from the Gaza Strip, I do think that Palestinians are definitely a target group of the law. And by the way, I didn't really do any empirical research yet, but I started looking at declarations, for instance, of organizations as terrorist organizations. They're nearly all Palestinians from the Palestinian authorities. When they talk in the committees, it was also clear they talked about, all these irgunei ma'atefet, these sort of organizations that help assist terrorist organizations such as Hamas. These were the main examples that came up in the legislation process. And I do think, as I said, that the counterterrorism law will be applied also to Jewish settlers, perhaps, and to Israeli Palestinian citizens, and maybe to other Israeli citizens. But I do think that Palestinians are definitely one of the main target groups. But maybe, we disagree. I don't know. I mean, that's at least how I read the legislation process.
I think that the empirical research will be critical here.
Yes.
I agree.
This law was already utilized against the Hills Nora.
Yeah.
Yeah, and they were declared a terror organization. It's very interesting.
Yeah. No, it is very. And I think that, I think Deborah is right, and also you are right. That these things need to fully answer this question. We'll need to look empirically at how the law is being used. We need to look at administrative decisions. We need to look at judicial decisions, also at the judicial discourse, and that's exactly the next part of the research.
And Arabs and Jews.
Arabs and Jews in Israel. That's what I hope to do next year. That's exactly what I hope to do. To look at Palestinian residents, Palestinian citizens of Israel, and Jewish citizens of Israel. And I think this will be really interesting. And I think that will enable me to answer Ellie's first question or criticism much better.
Great.
Right now, I can only sort of hypothesize.
And now we have Itamar, who's sitting in front of a beautiful sunset. Who knows where?
It's actually right here outside the window, but this is not the, but in a different
but it's
time
still
of day.
beautiful.
Thank you. I mean, yeah, I mean,
Makes us think that it's earlier than it is.
Yes. Rottem, a very fascinating conversation and talk. Thank you for this. I really enjoyed it. My first question is a simple one, and it follows up Eli's main point, but maybe from a different perspective. I didn't obviously do empirical research on this, but I do have some anecdotal firsthand knowledge because we have a project in our clinic that is based on observing in military courts in the West Bank. And I'm pretty convinced, pretty sure that this law is really not the main law that is applied on Palestinians for criminal cases having to do with security or political crimes. This is the Tzav Bidvar Horot Bitachon, or the, I guess, National Security Ordinance that is military in its basis, is still the main framework, legal framework for Palestinians, which you do mention in the beginning of your talk, but it seems underemphasized when you take the perspective that the anti-terrorism law is a kind of new format for a certain kind of subordinate citizenship. So I think that really raises a question about that thesis when you take into account that mainly, really, it's not applied on these people. So that's the first question. And the second question is, there's some, I think Ian Lustig, who is a friend of Gadi's, I believe, just published a book about, it's called Paradigm Lost. It's about the end of the two-state solution and the new kind of descriptive as well as normative paradigm in terms of what we need to hope for and strive for in this area. He's talking, of course, from outside of this area, but anyways, in order to achieve democratization between the Jordan River and the Mediterranean Sea. And he thinks we need to strive for democracy for everyone. And so if this is indeed a kind of normative horizon, what is the role of defendants in criminal trials? And do they have a participatory role to play in the way that they use the procedures and take advantage of their rights? I guess that's the second question.
Thanks. So first of all, I'm sure that the military courts in the West Bank are the last place where the law will be integrated, and I think that, you know, maybe it will be used in these prosecutions more later on. But I think that one of the interesting things about the counterterrorism law is that it focuses much more on the interrogation part of the process, or on the investigation part of the criminal process, than on the actual prosecution. And I think that these sort of tools, you know, that are meant to enable investigation, talking to suspects, stopping terrorist organizations from materializing their plans, declaring them as terrorist organizations, coming in and stopping, like, you know, the use of territory and things like that. This is, I think, the main emphasis in the law, and this is what I think we'll be seeing more, perhaps also in the West Bank. It relates. There's a very interesting book that came out by Sigal Shahav called Mishpat Plili Bitchoni. She calls this type of law security criminal law, and this is exactly her argument, that in the security criminal law, the emphasis of the criminal in the criminal process moves to the pre-trial stage. Now, I think this is, and I think this is what we might see happening also in the West Bank. The law used more for this part, even though I agree that there are other tools that Israel can use in the West Bank that might remain more dominant. And I think this is also a very important point with regard to your second question. You know, defense lawyers. Defense lawyers can be very, I think, can have a great impact in these these pre-trial stages and the interrogation stages. But I think that when it comes to really sort of fighting for their, maybe what I'm saying is not completely true, but I think that when it really comes to sort of creating narratives, fighting for your client's rights, reaching sort of, inciting a certain judicial rhetoric or sort of getting the legal system sort of on board with this idea of human rights, I think it's in a way easier to do in the trial stage. I think that a lot of the sort of performance and the type of sort of things that defense attorneys do, a lot of them, I think that a lot of these things maybe could be more useful in the stage of the trial, while in the stage of interrogation and investigation, defense attorneys sometimes are just helpless. They don't see the material yet. They don't really know what to do. So I'm not sure how efficient defense attorneys will be in this part of the criminal process, which I think is gaining more dominance. I definitely do that they will manage to do things in individual cases. I'm not sure overall, but I do think that this idea that a security offense should be tried and sort of perceived a little more similarly to a regular criminal offense does definitely, and the procedural rights also that come with it, do provide some potential, for defense attorneys to fight for the rights of their clients and at least gain some symbolic, victories. But I think it's a little hard to say at this point. And a lot of these things also need empirical research.
Well, it was a really interesting lecture and fascinating discussion. I don't see any other hands unless I'm missing it. Michal, am I missing? No. So first of all, it's wonderful to see everybody.
Ido is raising his hands, no?
Who is?
Ido.
Where? Ido.
Yeah, my hand is up.
Okay. Where is it? Yeah, I have to look. Go ahead, Ido.
Yeah. Sorry. Well, first of all, great, very interesting presentation, Rottem. And I do have, I'm not sure if it's somewhere between comments and questions, but there will be a question mark at the end of it, just to be on the safe side. As part of what you're saying, that there is a movement from seeing, due to the law, the Palestinians from an enemy to a criminal. So you see them more of kind of a person rather than an enemy, a combatant, or something like that. And I want to challenge that assumption, because usually, at least in my point of view, where we come from international law, you really differentiate between terrorism and the laws of armed conflict. Some acts of terrorism can be part of an armed conflict. Some of them can be outside of an armed conflict. It doesn't really have to be, and these are two separate systems. And moreover, since the conflict against Palestinians is considered a non-international conflict rather than a state versus a state or international conflict, then you don't have a combatant status to begin with, which is part of how you would define it, and therefore criminal law would be used to begin with. Within such a national criminal law would be used and applicable to every act of aggression done by the enemy against you. Unlike an international conflict where you have combatant immunity, and therefore you cannot put them on trial for the mere participation in conflict. So here, what you have in this law is basically the creation of guilt by association of every member of an affiliated with an organization which has been designated is therefore a criminal. And it's not necessarily moving forward, it's actually trying to build up on some of the weaknesses that criminal law doesn't give you and international law doesn't give you, and trying to stitch them up together into having your own solution, legal solution to this bizarre situation of terrorism on the one hand. If you look at the years, disengagement plan was definitely an issue there. And because the discussion started in 2006 and ended up later on, as Ellie said, took about a decade to complete that. And as a side note, if you also look at the political differences between the government we had in 2006 that began that law and the government we had when it ended, you can see a very, very big shift on the political aspect. And you can also see some of the safeguards that were placed in earlier versions were removed side by side and step by step, more accurately. And within that is the example of designations of organizations. You referred to the fact that there is a committee, but that committee is applicable to domestic designations of terrorism organizations, terrorist organizations. If a designation is based on a Security Council designation or a foreign state like the US or something like that, there is no committee. There used to be a committee, and they actually removed that committee, and it's an automatic designation of such an organization. So the way I would see it is that, yeah, definitely the law would put it as a conventional crime. I don't think it ends any affiliation to an armed conflict. Well, I promised a question mark at the end. Was it useful?
Yeah, it was. Thanks. Those are important comments. You're right about the foreign declarations. That's a very good point. And about the committee. And look, I mean, I think, and about other things you've said, like guilt by association. I think that's made part of the problem. So that's one of the things I remember that the Public Defender's Office, I think, raised, that whether the definition is too broad or not too broad. I agree. I think that it can cause problems of people who are not actually guilty of terrorism be guilty by association. I also agree with Eli that it's not necessarily a draconian power, but I do think that maybe the definitions could be more narrow. But the point about the foreign declarations and the committee that was removed is very important. So I'll go back to that. And, thank you.
Okay, so really, I want to thank you very much. It was really fascinating, Rottem, and the discussion as well. And I really look forward to reading some of the empirical findings. It was great to see everybody. Our next meeting is on the 26th with Amnon, and I guess it's at 9 o'clock in the evening as well. So see everybody then. Thanks a lot.
Thanks, guys. That was
Thanks very much.
helpful. Thank you.
Thank
Bye.
you.
Thank you
Bye-bye.
very much.
Good night.
Bye.
Lalato.
Good night.
Good night.